Arguably, when it's decided by the Supreme Court, it will be the single most important constitutional decision in all of our history. Yesterday's decision by the Colorado Supreme Court was masterful. It was brilliant, and it is an unassailable interpretation of the 14th Amendment, Section 3's disqualification clause.
Hi again, everyone. It is 5 o'clock here in Washington, D.C. I'm Alicia Menendez, in for Nicole Wallace. The decision that conservative legal scholar Judge Michael Luttig hailed as masterful and brilliant will soon be before the nation's highest court, with massive implications for the 2024 presidential election. Oral arguments begin February 8th in the case over Colorado's Supreme Court ruling, which said Donald Trump is disqualified from running for office again because he engaged in an insurrection. But ahead of that, both sides are laying out their case, the most recent coming from the ex-president just last night. He put out a 59-page brief that was filled with over a dozen arguments as to why the U.S. Supreme Court should reverse the decision out of Colorado. From that brief, quote, "The court should put a swift and decisive end to these ballot disqualification efforts, which threaten to disenfranchise tens of millions of Americans and which promise to unleash chaos and bedlam if other state courts and state officials follow Colorado's lead and exclude the likely Republican presidential nominee from their ballots." One of the most absurd points argued by the former president was over wording, saying that Section 3 of the 14th Amendment does not apply to presidents because he never swore to support the Constitution, which is what it says in Section 3. Instead, the presidential oath he took says to preserve, protect, and defend the Constitution. We'll dive deeper into that phrasing argument in just a moment. Meanwhile, over in Maine, the only other state to rule that Trump's role on January 6th disqualified him from running again, the Secretary of State there, Shenna Bellows, filed an appeal today to a judge saying her ruling should be paused until we hear from the Supreme Court. She writes, "Like many Americans, I welcome a ruling from the U.S. Supreme Court in the Colorado case that provides guidance as to the important 14th Amendment questions in this case. In the interim, Maine law provides the opportunity to seek review from the Maine Supreme Judicial Court, which I requested today. I know both the constitutional and state authority questions are of grave concern to many. This appeal ensures that Maine's highest court has the opportunity to weigh in now before ballots are counted, promoting trust in our free, safe, and secure elections." While Maine and Colorado are the only two states that have ruled Trump is ineligible to be on the ballot, there have been challenges to his candidacy in nearly 36 states, and decisions in 17 are still pending. And that is where we start this hour with former U.S. attorney and co-host of the podcast #Sisters-in-Law, Joyce Vance, plus former acting assistant attorney general for national security at the Department of Justice and co-host of the MSNBC podcast Prosecuting Donald Trump, Mary McCord. And back with us again today, MSNBC legal analyst Lisa Rubin. Lisa, let's talk about this Trump filing, because I consider it in the wave of amicus briefs that have already been filed and just the sheer volume of arguments before the justices. How do they sort through them?
Well, Alicia, how do they sort through them and in what order they sort through them is up to them. But to the extent that this Supreme Court wants an off-ramp, it obviously can take one of those things before it dispenses with some of the more complicated arguments here. So, for example, if the Supreme Court were to hold that the Colorado plaintiffs don't have standing to sue Colorado Secretary of State Jena Griswold for neglecting her duty to decide qualifications that was critical, for example, to the Supreme Court's ruling in Colorado, they could do that. And by doing that, that would alleviate their need to work through any of the other arguments. They can also always decide questions of standing, for example, without the parties having to raise them.
Joyce, let's talk about that sticky wording question. The former president arguing he didn't take an oath to support the Constitution, just to preserve, protect, and defend it. Our own Jordan Rubin from the Deadline legal blog calls the argument, quote, "too stupid to consider." Do you agree, Joyce?
Yeah, I think that that's sort of the converse, right, of too smart by half. Look, this is the sort of argument that's well suited for argument before the Supreme Court because it's a purely legal argument. And one of the problems, frankly, that Trump faces here is that he really wants to put all of his eggs in the "I didn't commit insurrection" basket. But the Supreme Court is not a trial court. It doesn't hear evidence. And except in cases where it can say that the finder of fact just got it completely wrong, that no reasonable judge or jury could have reached the conclusions they did, the Supreme Court accepts the facts that it's given from the lower court and makes its decision based on those facts. So these sort of legal convoluted arguments about the language of the Constitution have a certain amount of appeal. This one is sort of crazy when you think about its implications. You know, judges like to tell juries they don't have to leave their common sense at the door. Well, it defies common sense here to think about the fact that the president alone among all constitutional officers has no obligation to uphold our laws, to uphold the Constitution. I think Lisa's right when she says the court will look for a procedural off-ramp. I don't think this will be it.
Well, Mary, there's something that Trump argued that his challengers actually agree with. I want to read a little more from the brief. Quote, "A ruling that reverses the Colorado Supreme Court while remaining agnostic on President Trump's eligibility under Section 3 will only delay the ballot disqualification fight," right? There is this sense that whatever they decide has to be applied broadly. Speak to this moment of a very rare agreement and whether you think the Supreme Court ultimately decides this issue completely.
Well, I think, the challengers here knew from even before they filed this case that the definitive resolution would really have to come from the U.S. Supreme Court. And so I think that's why they did not oppose the court accepting cert, accepting review of the case. They opposed on a few of the issues, but not on the court taking the case to resolve sort of the bigger overarching issues, the issues that would then apply in all 50 states. And I think they recognize, as do most litigators and people looking at this, that if the court sidesteps sort of the central key legal issues, you could potentially have a situation of different application of Section 3 of the 14th Amendment in different states. And that would really be pretty chaotic and doesn't seem to be consistent with what could have been anticipated by that amendment. And so even the challengers now that we're up in the Supreme Court, they are the respondents. They were the initial challengers in Colorado to Mr. Trump being on the ballot. Even they agree that the Supreme Court should resolve some of these legal issues that Joyce was just pointing out. I think that one distinction is that the challengers would, as Joyce also pointed out, not think that the Supreme Court should review factual findings made by the court in Colorado, and that it is certainly the case that courts of review, appellate courts, and certainly the Supreme Court rarely will undertake making factual findings as an initial matter. Now, some of these issues, like did Donald Trump engage in insurrection, have some combination of facts and law, because one question is, what is an insurrection under law? It's not defined in the Section 3 of the 14th Amendment. It's not defined elsewhere in the Constitution. What does engage in mean? Here we can look to other application of other statutes and what the term engage in means. So the court could give some rulings about sort of those legal questions, what's an insurrection, but I don't think we'll see the court really reviewing, other than for the clearest of error, application of that law to the facts.
I wonder, Joyce, what you make of the fact that the word bedlam made it into this document, given the conversation that we always have about, is Donald Trump listening to his lawyers? Are his lawyers listening to Donald Trump? Are they making a legal argument? Are they making a political argument? Your sense of who's the dog and who's the tail here?
Well, I think here, unlike what we've been watching in New York, the spectacle that we've seen in court there this week, Donald Trump has got people who understand how to handle a case in front of the Supreme Court. They've written a pretty straightforward brief. I don't think lots of Donald Trump's direction has led to this particular filing. But, the bedlam argument, Alicia, is particularly disturbing, especially since Donald Trump is asking the court to make a finding that he would never promote an insurrection. How odd to make that argument, but at the same time to say that if you take me off of the ballot, there will in essence be disquiet in the country. And this speaks to who Donald Trump is, because if he really believed this argument was true and if he really believed in the Constitution, he would simply tell his followers, We will follow whatever decision the courts of law make. There will be no bedlam. There will be no violence. We are a rule of law country. We will follow the law. And of course, Donald Trump never says anything that approaches that. Instead, he resorts to these implicit threats.
Lisa, I want to